focus here on the Hague Service Convention. This treaty was signed in 1965. It's actually viewed by many as one of the most successful international treaties of all time. There aren't a huge number of signatories, only 58. Mexico is a signatory, as is the United States. I would personally describe it as one of the 3 or 4 most successful treaties that I'm aware of, and I'm aware of a lot of treaties. And the reason I say that is that it is one of a handful of treaties where courts across nations and where the nations themselves who have signed on and who've ratified the treaty are fairly consistent in applying the treaty. So there's a fairly consistent understanding of how the treaty would apply. And that makes it, I think, a successful treaty in that sense. That's my definition of success. I'm going to be talking a lot about the Hague Service Convention, and I provide here for you the link to the Hague Service Convention's website. I'll also mention it in a variety of other places over the next 10 or 15 minutes. The most important thing I can tell you is that website is one of the best that I know of in any setting, actually. It's extraordinarily user-friendly. It contains a lot of information. And I'll show you when we do, because we'll walk through a case-by-case analysis looking at Mexico specifically, and I'll show you some screenshots of what information you can glean from the Hague website. It's a tremendous resource. And again, it's exactly the kind of thing that these purported service providers, service of process providers, claim that they can do for you and expedite for you. And once you have access to this Hague Convention website, which again is free and available to the public, there's really no information that they have that you can't get from that website in a Hague Service Convention context. There's also a link there to the members, so you can see what countries are signatories, have ratified the treaty, and are bound to the treaty. And this is the link to the homepage of the website. So because the Hague Convention, again, has several different conventions, so you want to make sure that you go to the Hague Service Convention, and then you'll focus on the Hague Service Convention treaty, the document itself. That's the first link. The members, the second link. I'm going to walk in some detail through the major articles of the Hague Convention on service. The first, we start with Article 1. The key parts here: this convention applies in civil or commercial matters. That's been interpreted very broadly, and that there's been a certain amount of litigation over that question. Is this a civil matter? Is it a commercial matter? All of the matters of custody, parental rights, divorce would fall in the category of civil, so they would be covered. Where there is occasion to transmit a judicial or extrajudicial document for service abroad. We'll see in a little bit a very controversial United States Supreme Court decision that is interpreting that phrase, where there is occasion to transmit a judicial or extrajudicial document for service abroad. And we'll see that the United States Supreme Court took a somewhat controversial position, but the other signatories to the Hague Convention were not troubled by the position the United States took. Finally, the convention does not apply where the address of the person to be served with the document is not known. So you must know the address of the person you're serving. This is important because in a certain number of the cases, again, in talking to Tammy that some of you may be dealing with, you may not know the address of the person to be served. And if that's the case, even if you're serving in Mexico, which is a signatory to the Hague Convention, you will not be able to use the Hague Convention. You cannot avail yourself of the Hague Convention because you do not know the person's address. Next, Article 2. Article 2 requires states to designate a so-called central authority, which is the entity within a country that receives any requests to perform service. The central authority is publicly known, and as you'll see in a little bit, it's available on the Hague website. Another wonderful feature of the Hague website is you can go on there and it will give you the address. It will actually give you the contact information for the addressee you should send your request to. So in some cases, there may be a single central authority. In others, there may be more than one. In the United States, as I mentioned a little while ago, there are actually 2 central authorities. There's one within the Department of Justice, another within the Department of State. Most countries locate their central authority in their Ministry of Justice, their equivalent of our Department of Justice. Some also put it in their Ministry of Foreign Affairs, our State Department. and states are given autonomy, sovereignty to choose their central authority for themselves. As you see, in Mexico, the Ministry of Foreign Affairs, and we'll talk about this when we get to the Mexican case, is the central authority. Article 5 talks about how the service will actually be affected. So this is actually interesting to know. Sort of how does it actually happen? You send your document to the central authority. What are they going to do with the document once they get it? Well, there are a range of options provided for the central authority. The central authority will serve the document itself, or it'll have an agency do so, either by a method that is prescribed by their own internal law, so however service would be conducted in their country, or by whatever method you request. So you actually have the right to request a method unless that method is incompatible. So you could request, for example, personal service, service by mail, and so long as that method is not incompatible, you can request a method. There's a downside to requesting a method, though, which is that in the event that you choose to serve by a particular method, actually in either case, the state may require you to translate the document or write the original document in the official language of the state address. So in Mexico, they can require you to, and as we'll see, they do require you to submit the document in Spanish. I don't have it here, but the Hague Service Convention actually has two forms that it appends that are at the back end of the Hague Service Convention, and on those forms, we see actually all you have to produce, which is just a quick summary of whatever document is being included. Again, this is where these service companies aren't really providing a service. The convention itself provides the forms, and they're both very short when you're passing along information. Article 10. Now, Article 10 is I'm taking this out of turn. I'll come back and talk about a couple Articles 6 and 8 here in a minute. Article 10 is the thorniest article for the United States, particularly when we're talking about service by mail. So Article 10 technically allows states to use service by mail in three different ways. Service by mail where I'm serving, service by mail where I ask the court to serve, or service by mail where a person interested in a proceeding can serve through judicial officers of the receiving state. So if we were sending from the US to Mexico, judicial officers in Mexico. It allows all three of these mechanisms, but importantly, a state signing on to the treaty has the right to object to one or more, indeed all of these mechanisms, and a number of states do object to service by mail, including Mexico, as we'll see shortly. And so Article 10 was a heavily negotiated provision in this treaty. The compromise was to include it. The United States pushed for that, but to include this language that allows states to object. And we'll see that they're given a reminder later in the treaty of their right to object. And again, one of the nice features of the Hague Convention website is that the Hague Convention website actually allows you to go, when you click on, let's say, Mexico. I'm choosing that because it's a country we'll be talking about in depth shortly, and see whether Mexico has objected to or had reservations on any of these provisions. And if so, you know you can't use Article 10A, for example. As I mentioned, I skipped over Article 8. Article 8 allows you to use diplomatic or consular agents. So what that means is you, as a practicing lawyer here in the United States, can actually use a U.S. consular official located in Mexico to effect service. You're allowed to do that. This is one of the many roles that consular agents have. Again, I don't know in our current administration how much time consular agents will have to effect service. I think they'll be spending a lot of time processing visas and paperwork. That would be my guess, at least. And if the budget goes through, they'll be cutting down on the number of consular officials. So, and here Mexico may not be the best example, but suffice it to say, if you were in a state that has a Hague Convention relationship with the United States, you could use diplomatic or consular agents so long as that state is not opposed to using that method of service. Now, again, this would appear on the Hague Convention website, namely that the state so Mexico could declare that it is not comfortable, it is opposed to service using diplomatic or consular agents. That would restrict you. Again, you could find that on the Hague Convention website. But notice one caveat at the end of Article 8, which is that even if Mexico were to say that it's opposed to service on using diplomatic and consular agents, and again, why would you use this? It would be to bypass the central authority, because there might be a backlog, say at the Ministry of Foreign Affairs in Mexico or the Ministry of Justice in Brazil. And so you might use this. Again, you might try both mechanisms, Article 6 and Article 8, as a mechanism for getting to serve as many ways as possible, which, as you know, is one of my mantras in this presentation. Now, there's one exception to that, which is if you're serving a U.S. national, if the documents originated here in Mexico, even if Mexico is opposed to that service, you can still use U.S. diplomatic or consular agents. So if the person to be served is a U.S. citizen, you can use diplomatic or consular agents regardless of whether there's a reservation on Article 8. And again, that in some cases can be relevant. Article 15. This is a long article, and I'm not going to go through it fully. I'll lay out the full item here. This is all of Article 15. Oops. This is all of Article 15. I want you to see this because this Article 15 relates to the rules for, which comes up, I think, quite regularly, for getting a default. So how one can get a default and what states can do to avoid default judgments. So what I would simply say here is the Hague Service Convention allows for a default to be issued. You have to meet certain requirements to get a default judgment. I think the most important thing to say is that this has a higher standard than Rule 55 on defaults would otherwise have. So it's a higher standard for getting a default judgment. And that's, again, intended to protect private actors in Hague signatory countries. It's intended to have a line that says, by signing on as a country, I am protecting my citizens and those acting in my country in certain ways, and there's a higher bar to service of process to default in a Hague Convention state. Article 7 just talks about the languages to be used. This is, I like to say, one of the last bastions of the relevance of the French language. I say that tongue-in-cheek. I speak French, but I don't get to use it very often. I use it occasionally to appear fancy when ordering a wine, and occasionally in international law settings. Those are the places where the French language issue can come up and be helpful. But French is still a language of use in the international law setting, and so those are the two official languages that can be used. You can also write the document in a language of the state or one of the official languages of the state in which the documents originate. That, again, since it would be in the United States, it would be English in any event. These are what this is saying. The second part of Article 7, the second bullet, is pointing out the two forms that I talked about, which you can find on the Hague Convention website. Very short forms. All it says is that you can do it in the language of the state address, so in Spanish if you were going to Mexico, for example, or in French or English. Article 9 allows states to make treaties on their own. So this is what allows bilateral treaties and other multilateral treaties, like we'll see in a little bit. And so it's just a reminder that the Hague Service Convention, even when it was being negotiated and signed, was not intended to be an exclusive mechanism for service. Article 11. Article 11, again, goes to this point of additional service of process treaties allowing states to sign on to other treaties. So you can have more than one treaty on service of process. Article 19 is one of the more controversial articles in the treaty. And what it does is it's really intended to be focused not on the United States. So it says that to the extent that the internal law of a contracting states permits methods of transmission other than those provided in this treaty. It's a very short treaty. 19 is towards the back end. that the treaty does not affect those provisions. So it allows additional mechanisms. So in other words, you could have a situation where the U.S. allows certain service that other states do not allow. Mention a few other articles that I don't touch on here, but that are worth mentioning. Article 6 talks about enforcement. Article 12 talks about costs of service. It turns out that you can't be charged exorbitant costs when you go abroad. The state can ask you to pay for reasonable costs associated with effecting service, but they can't charge you exorbitant costs. Article 13 deals with a state's refusal to comply with service. Article 14 talks about settling differences between states. 16 is the last one I want to mention. It's a companion to Article 15. Article 15 is about getting a default. Article 16 talks about getting out of a default judgment. I mentioned there's one major case that deals with service abroad in the U.S. Supreme Court that deals with interpretation of this treaty. It was a case involving Volkswagen. It involved a car accident in Illinois in the 1980s. The family of the man who was killed, Mr. Schlunk, sued Volkswagen in Illinois state court. And what happened in the case was they sued, and this is a matter taking you back to first year civil procedure, depending on when you attended law school. Most likely you studied the case of Worldwide Volkswagen versus Woodson. It was part of the jurisdictional revolution that took place between 1977 and 1986 in the U.S. Supreme Court. In many of the cases that have created jurisdiction law, and actually a lot of international litigation cases, involve Volkswagen. It's not because Volkswagens are made any more faultily than other vehicles. It's because of the structure that Volkswagen has chosen to use, the corporate structure here in the United States. So Volkswagen has a parent company located in Germany known as VW AG, and it has an American subsidiary, VWOA, which is its importer and distributor in the United States. It also has a variety of other subsidiaries here. The plaintiffs were suing both VWOA and VWAG. They affected service on VWOA in the United States. That was fine. They used Illinois state law. They also, and it was a U.S. Entity, so it was not a problem to affect service in that way. But both Germany and the United States are signatories to the Hague Convention and were signatories to the Hague Convention at the time, and they chose to, the plaintiffs did, to also serve VWAG through the American subsidiaries. So they served them through service here in the United States. And VWAG brought a motion to quash service. It's made its way all the way up to the Supreme Court. And the question was, here's VWAG, this party in Germany. And the claim of the German entity was, it's very clear in Article 1 that you must use the Hague Convention in a civil or commercial matter when both states are signatories. On its face, I happen to agree with that position. It seems quite clear. This was a civil commercial case, in fact, civil matter. And it would appear that service on this German company should be accomplished through the Hague Service Convention. But the Supreme Court read Article 1 differently. And what the Supreme Court decided in interpreting Article 1 was that the question was whether there was occasion to transmit a judicial or extrajudicial document for service abroad. That was the language they were focused on. And in their reading, under the agency laws of Illinois, this case was taking place in Cook County, Illinois, it was reasonable to serve the parent company, VWAG, through its subsidiary, VWOA. And therefore, there was no occasion to transmit service abroad. Here, it was optional to use the Hague Service Convention, but the Hague Service Convention was only mandatory where you could only serve abroad. Here, using state law of Illinois, it was reasonable to serve domestically. I'm getting a little bit academic here, but I'll just say the interesting thing about this is it kind of undermines the purpose of the treaty. And the effect of that is, from where I sit, a problem, because it makes the treaty less efficient. if the goal is to streamline service of process, VWAG now needs to know the laws of all 50 states in the union on agency, for example. And so that ends up being a bit of an issue, I think. But it is true that technically, applying the law of Illinois, there was no occasion to transmit a judicial extrajudicial document for service abroad. It could be done domestically, and so that's what the Supreme Court held. As I told you, this is a very successful convention, and the signal of its success is that in spite of this decision, which seemed somewhat parochial and counter to the purposes of the treaty, no states withdrew, no states changed their position on the treaty. The only effect is that now if you're serving abroad, you may need to know the local level law in the country in which you're serving, because they too may have special rules in the corporate setting. Again, this is less likely to come up in the individual setting. There's one South Carolina case that I think bears mention here, Bacala versus Bacala. This was a divorce case initiated by a wife against her husband. Here, the family court granted divorce on the grounds of husband's adultery and equitably divided the marital estate and held the husband in contempt for noncompliance with its order. The husband appealed, and the Supreme Court held that the husband was not prejudiced by a post-divorce hearing ex parte communication between the trial court and the wife's attorney regarding valuation of the marital stock. He wasn't deprived of actual notice of documents served via mail abroad, and then some other evidentiary issues. It affirmed the district court. And the key here, as I point out in this bullet point, is that because he didn't raise the issue on service in the trial court, he'd waived his claim on appeal. So we don't know for sure what would happen had he raised the issue at the trial court level, but this is the one case where the state Supreme Court here in South Carolina has addressed the Hague Convention. It's a reminder, actually, in some ways, of the importance of the Hague Convention in both state and federal court cases. Again, additional language just laying out in this divorce setting involving the Czech Republic how the court treated Article 10A of the Hague Convention. Remember, 10A, as we talked about a few minutes ago, is the article on which a state can object and therefore not have it apply. The Czech Republic had not objected. All right, back to our overview. So you see we're getting close to the end, or closer to the end. We've covered rules 4E and F of the federal rules, state rule 4D. We've talked about the Hague Service Convention. We turn now to the Inter-American Convention on Letters Rogatory and the additional protocol. Again, a reminder that it's those two documents together that we are the most focused on. This treaty provides additional options for service of process. I'll refer to this treaty often as the Inter-American Service Convention. Again, what can be confused is that these are a pair of documents and that countries must be a party to both agreements in order for a treaty relationship to exist with the United States. The goal of this treaty is to replace the traditional letters rogatory process by providing a mechanism for service of documents by a foreign central authority. Under this treaty, it's the Department of Justice that is the U.S. Central authority. Now, it's important to note that the Hague Convention that we talked about deals only with service. I told you that there's also a Hague Convention on the taking of evidence, or the so-called Hague Discovery Convention. This Inter-American Convention deals with letters rogatory and a variety of other mechanisms, which can include taking of evidence, but it also includes service. And my focus here today, because of the nature of this webinar, will be on service of process. For those of you who haven't dealt with letters rogatory, I imagine many of you have. Letters of rogatory, also known as letters of request, are requests from a court in the United States to a foreign court requesting judicial assistance. It can be used to obtain evidence, to conduct service of process, and the like. In some countries, service by letters rogatory is the only recognized method of service. That's a continental European approach that was transmitted through the French and Spanish and Portuguese actually to a number of countries across the globe over the course of the last 150 years. You'll notice that the procedural requirements vary from country to country. The major problem with letters rogatory is that it can be a very time-consuming process. So my advice is to use it only when you have no other options for serving process. And again, going back to Rule 4F, I would recommend that using letters rogatory as one of several mechanisms. That would be my recommendation. For those not familiar with it, I'm not going to read this out, but again, just for the sake of completeness, in this presentation, I provided again, courtesy of Westlaw, 22 CFR section 92.54, definition of letters rogatory for your benefit. All right, let's learn a little bit about the treaty. First, every state, as I mentioned, has to establish a central authority, just like the Hague Service Convention. Sometimes it will be the same central authority if you have a state that has both the Hague signed to both the Hague Convention and the Inter-American Convention, but that's not required. Again, you'll need to research to make sure that that is in fact the case. Just like with the Hague Convention, that central authority receives the documents and then transmits them. As I mentioned, there's both a convention and an additional protocol. And as you see here, the additional protocol was adopted for the purpose of clarifying the procedures for transmitting letters of request and applies only to requests involving service of process, summons, or subpoenas. So taking out subpoenas in Rule 45, this is why you have to have the additional protocol, because in order for service of process to be in play from the Inter-American Convention, you have to have the additional protocol focused on service of process. The goal of the Inter-American Convention is to ensure that defendants sued in foreign jurisdictions receive actual and timely notice of the suit, and it also is intended to facilitate proof of service abroad. The Inter-American Convention, I'll just say, is somewhat less sophisticated than the Hague Convention and somewhat more complicated to work with and to use. The Inter-American Convention does allow use of diplomatic channels as well, but again, it's generally the central authority that one would use for the transmission of letters rogatory. In order to use letters rogatory, you also have to have a consular or diplomatic agent in the United States legalize the documents. That is not required if you're using consular or diplomatic channels or the central authority. So that's the benefit of using a central authority. It's the benefit of using the treaty. Doesn't require legalization, notarization, as it were. Note that courtesy of the ABA, there's been some evidence that courts in border areas of signatory countries may directly execute the letters rogatory without need for legalization, just because of the amount of cross-border transactions. And here one might think most easily of the United States and Mexico, at least as things currently stand. So what do you have to provide? You have to duly translate the language. You have to provide an authenticated copy of the complaint with supporting documents and any other exhibits, written information that identifies the entity who is suing, how long the defendant has to act, and the consequences of failure to act. In other words, putting on notice a recipient defendant of what the system is in which they find themselves at a given moment. And to the extent it's relevant, the right to court-appointed counsel or legal aid societies in the United States, which would be the country of origin in this context. Again, probably not applicable here, but worth mentioning. So let's look at the scope of this convention. Article 2 provides the scope of this treaty. It tells us that it applies to letters rogatory issued in conjunction with proceedings in civil and commercial matters. We've seen that before, of course, from the Hague Convention, and that for matters before judicial or other judicatory authorities of one of the state parties that have as their purpose the performance of procedural acts of a merely formal nature, such as, and here you go, service of process, emphasis added by me. The treaty therefore covers service, even though it is not exclusively focused on service. Article 1, the scope of the protocol, again, just for overview, talks about various procedural acts that can be accomplished and that are involve transmission from one state to another using a letter rogatory through the central authority process. Article 2 also tells us that each state must designate a central authority. Again, as I mentioned earlier, just like with the Hague Convention, it requires, interestingly here, Article 2 requires that the central authority of the originating state transmit the letter rogatory to the central authority of the destination country. So it requires intervention by both central authorities. So here, if you're using an American Convention, you'd have to go through the Department of Justice to initiate the request to the central authority in Mexico. That's quite different from how it would work under the Hague Convention, where you would not need to involve or invoke the U.S. central authority. Articles 3 and 4 provide the requirements for the preparation of letters rogatory. 3 deals with preparation. 4 deals with transmission and processing. 5 talks about costs and expenses. Central authorities, just like we saw with Article 12 in the Hague Convention, may seek payments by parties for costs incurred. So it's not going to be done gratis, but the goal is to keep costs down, and you can't be charged exorbitant costs. And again, here's access to the full document. This is on the website for the OAS, the Organization of American States. One case I'd like to just draw your attention to is a federal case from the Fifth Circuit from now more than 20 years ago called Kramerman against Casa Veerkamp that dealt with an issue related to the Inter-American Convention. It's the only case I'm familiar with where a federal appellate court or the Supreme Court has dealt with this treaty. In that case, the issue is whether the Inter-American Convention on Letters Rogatory preempts all other conceivable means for effecting service on a defendant who resides in Mexico. The answer was no. So the court does not require that as a preemption on other methods of service. I will say that because of the drafting language of that treaty, it was a much closer question than was the issue in the Schlunk case. Now, this case came down 6 years after Schlunk, which we talked about earlier, the Volkswagen case interpreting the Hague Convention. Just to mention briefly the protocol and some of its requirements, you can find actually on the website of a contractor for the Department of Justice. It doesn't require formal letters rogatory. You just have to provide the original document and 2 copies of the form, 3 copies of the summons and complaint, or whatever else you intend to serve. And you don't need to translate the form itself, but you do need to translate the documents themselves. Generally, it takes, and now this varies from country to country, 6 months to a year for a request to be executed. And again, the Organization of American States website will give you additional information. By the way, an additional resource I'll just mention is and I have it here at the bottom of this slide, is the State Department website, the U.S. State Department website as well. As I mentioned before, the U.S. only has a treaty relationship with countries that are party to both the convention and the protocol. We're going to see shortly that is a fairly limited number. Of the 4 countries that Tammy asked me to focus on, only 1 actually applies, in fact, Mexico. So here's a list of some of the countries. I focus on Latin America, again, based on my conversations with Tammy, but you'll see it's mostly in South America. Guatemala does have this relationship, Panama as well. So if you have both the IACAP, or the Inter-American Convention, and the Hague Convention, generally the experience is, and my recommendation is, to use the Hague Convention. It's just a much cleaner mechanism, a much cleaner document. And again, it allows you to serve directly. You don't have to go through the clerk of court and the U.S. Central Authority. It's just much more user-friendly and frankly less expensive and time-consuming. All right. That wraps up my discussion of the overarching aspects of service of process. Seems like there are a few hardy souls who've remained with me throughout this. I want to wrap up by talking about, I want to spend maybe 15 minutes or so giving you a little bit of a spotlight on individual countries. And again, I'll focus on just a few. I'll focus, the four I'm going to focus on are Mexico, Guatemala, El Salvador, and Honduras. Of those, only Mexico is a signatory to the Hague Convention. As to the Inter-American Convention, both Mexico and Guatemala are parties to both the convention and the protocol. El Salvador is a party to the protocol, but not to the convention itself. So for our purposes, it doesn't help. Although you can try using the protocol, you may get lucky, but the reality is that technically the treaty doesn't apply since you don't have both documents. Already mentioned this. I'm going to focus now one by one. I'll focus on Mexico first. The good news is that the Hague Service Convention and Inter-American Convention both apply. The bad news is it can be a very slow process because the mechanisms in Mexico are among the slowest of any of the 58 Hague Convention signatories, unfortunately. So again, remember that there are other mechanisms that one can use. Here's what I told you. These are just screen captures from the Hague website, but this is what you would get by going onto the Hague website. So if you wanted to use the Hague Convention to serve process in Mexico, you'd get the address, you'd get the specific name and address, mailing address, along with a telephone number of the office that you would be sending your request to. You get a fax number, an email address, you get their broader website. And indeed, you get the name often of a contact person. That can sometimes be out of date, but it's still a useful document. And then, again, going back to my discussion of the Hague Convention, the Hague website will actually list out for you a variety of different questions. So I talked about Article 5, different translation requirements. You see here that in Mexico, when the judicial and extrajudicial documents to be served in Mexican territory are written in a language other than Spanish, they must be accompanied by the corresponding Spanish translation. You see with regard to Article 12, the cost of service, that the costs incurred by serving will be covered by the applicant, so you have to pay the actual costs of service. You see with regard to Article 10, which we discussed, and I sort of again foreshadowed this, Mexico has opposed the mechanisms, including service by mail, both by me as a party or a lawyer representing a party and by the court. It has a blanket objection to Article 10. You see that Mexico has some concerns about some subparts of the default provisions, Article 15, subsection 2, and Article 16, subsection 3. You see Mexico's opposition to Article 8.2. Remember, Article 8 was the provision that dealt with using consular officials. So what that tells us is that we have consular officials in Mexico. We can use them to serve U.S. citizens in Mexico, but not to serve Mexican citizens in Mexico, or for that matter, non-Mexican citizens who are also not American citizens in Mexico. For the Hague Convention, by the way, we're focused on residence for these treaties, where you are physically located rather than citizenship, except in this one situation. In other words, when we're talking about using the central authority, we're not interested in what citizenship anyone has. We're only interested in where they are physically located at the time of service. And I've already covered most of this. Article 2 tells us who the Mexican government has presented as their central authority in the Ministry of Foreign Affairs. Article 5, I've just talked to you about. Article 6 tells you that the whoever handles, whichever judicial authority which handles this actual passing on of the service request, also has to provide a report back. Article 6 of the Hague Convention requires, there's actually a form you fill out, requires the central authority of the country where service is affected to return to you a document that shows that service was completed. That gives you something that you can take to the court when you're seeking default or default judgment, and you can show the court that the Hague Convention service mechanism has been followed, and that's sort of a requirement on the receiving country, essentially. This is actually the language from Mexico. It will be much appreciated if the blank, so it's not mandatory, but suggested. I've already mentioned Article 8 as well as Article 10. You have to use the central authority in Mexico. So Article 12, again, just repeating some things that I've already pointed out, giving you hopefully the information in several different ways. Article 15.2, which I was talking about, is about allowing a default judgment to issue or default to issue before getting back the form in Article 6 that shows that service was actually affected. And then the provision of Article 16. As I mentioned, Mexico and the U.S. are also parties to the Inter-American Convention on Letters Rogatory and to the Additional Protocol. In the U.S., we actually use a contractor. There you go. You don't have to use federal government. The Department of Justice has hired a contractor, Process Forwarding International, PFI, which will transmit to the Mexican Central Authority. That's a good big business if you can get into it, by the way, being the contractor for DOJ on this kind of stuff. It's a pretty pro forma thing, so you would actually send it to this actor. Notice this website, just be very careful. This is a private actor's website. It's a .net website, so you're not dealing with an intergovernmental organization website like you were with the Hague Convention website. Again, there's a contractor who handles it on behalf of the U.S. government. I'm not going to walk through all of this information. This comes from the American Bar Association website, but I just thought it'd be valuable, again, to give a little bit of extra information about the process within Mexico of using the Inter-American Convention for service and how that process actually works. Give me a second on that. And then here I'm just going to provide you, again, this will all be made available. Brandon will be making it available shortly for you. All of these resources. Here are all the helpful links that I found, I should say that Jessica and I found for service of process in Mexico. Turn to Guatemala just to show you how much trickier it is when you don't have a case as easy as Mexico. Not a member of the Hague Service Convention, so that's out, but you do have the Inter-American Convention. Here is the information on contacting the Central Authority in Guatemala City. And again, this will all be available to you in the PowerPoint, so you don't have to scribble it down. El Salvador, as I mentioned, is not a member of the Hague Service Convention. It is a member of the additional protocol, but not to the treaty itself. So the U.S. does not have a treaty relationship with El Salvador. So you must translate letters rogatory and accompanying documents into Spanish. The original English language document must also be authenticated for use, and it must bear the seal of the court in the United States and the signature of the judge. You see how much more onerous this is in terms of the requirements both on you as a party and on the court system in the United States where that's the case. Finally, Honduras, a non-member of the Hague Service Convention. Here we go, opposite of what we just discussed of El Salvador. Honduras is a party to the convention, but not a party to the additional protocol, and therefore, again, doesn't have the treaty relationship. Therefore, you're going to have to use letters rogatory using diplomatic channels. That's the recommended mechanism. In theory, one could also attempt other methods of service, again, using the sort of 4F3 mechanism. Here are just a few resources and tools that I've talked about overall. We're getting close to wrapping up here. On 4F, federal and state, the two major treaties. I should add, we've done a pretty exhaustive search. There aren't other regional treaties either. These are the two major players, the Hague Convention, the Inter-American Convention. So if you're not finding it and there are no bilateral treaties, don't question your judgment. That's all there is. And so then the question becomes, how can you put a party on notice? And I guess I want to emphasize to you not to spend money on the exorbitant fees of these services that offer handling the service of process for you. I don't think they're doing very much. They're not doing anything more than you've seen in this webinar. I think here you have all the information and resources you would need to carry out service of process effectively. Those services really don't know anything more than you do. The only thing they have is they have more experience, so they're a little bit more comfortable doing it. but the fees that they charge, I just don't think are worth it. And I would say that whether you're a practitioner who has limited resources or if you're at a very large law firm with extensive resources, I think it's true in either event. There's some additional resources on the Inter-American Convention, the Mexican resources. And I'm providing for you, I'm just trying to do it here one by one, but I'll provide for you, again, all of the various cases that we've discussed, I think except for Crimerman. And remember that the citations for all those cases are in the bottom of each of the cases. And with that, I wrap up. I want to thank you for your attention. I wasn't sure how long this would take. My hope was to do it within an hour and a half, and that indeed is what my window has been. I'll stop, pause here, and see if anyone has any questions. We haven't gotten any during the course of the presentation, but I'll just give it 1 minute to see if anybody has any questions for me. See none. What I'll finally close out by saying is you have my contact information here. Should you have any questions, either immediately after this presentation or at any time when you confront a particular situation, please feel free to reach out to me. I'd be happy to do my best to address any questions you may have. Again, thank you for your attention. I'm very grateful to those of you who were able to listen live throughout this presentation, and for others who listen to the recording. I hope that this proves helpful to you.